Excellent. All right, well, thanks very much for that introduction, Kerry, and thank you to all who've registered to participate in today's webinar. Today's webinar is going to be in relation to the security of payments legislation in Western Australia, so that's known as the Construction Contracts Act, which was very recently amended late last year after a number of recommendations were made to government. So I'm going to be covering off on a range of issues in relation to the Act. As Kerry mentioned, my name's Michael O'Kane. Some of you may already know me. I'm a workplace advisor in the Perth office of the HIA, so I can assist members with all matters concerning security of payment, contracts, employment, industrial relations, the full spectrum of issues that builders and other people in the residential industry deal with. Now, just at the outset, I always like to emphasise that the purpose of today's presentation is to give a high-level overview of issues concerning the Construction Contracts Act, and that it's always going to be appropriate to seek specific advice from us at the HIA so that we can tailor our advice to your individual set of circumstances to ensure you're getting the best information that you need to deal with your particular matters. Now, to dive straight into what we're going to be covering today, we're going to be covering three broad topics. Firstly, I'm going to be talking to you about what this legislation, the Construction Contracts Act, or the CCA, is about, what it's intended to achieve. I'm also going to talk about the implied contractual terms that the Construction Contracts Act implies into all construction contracts in Western Australia, and we'll also in this section talk about what exactly is a construction contract for the purposes of the CCA. And then in the third part of the presentation, I'm going to deal with one of the key features of the construction contracts legislation, and that is the rapid adjudication process for resolving payment disputes. Now, as some of you may be aware, this is really the hallmark of the Construction Contracts Act, that it provides a rapid and cost-effective means of being able to resolve payment disputes with a client or a contractor very, very rapidly, much faster than, say, if you had to deal with the matter through the courts. And then finally, we'll finish off with a question and answer session whereby you can type your questions into a text box and I'll endeavour to answer them. And then also after this webinar, we'll be sending to participants a number of HIA information sheets concerning further information in relation to the Construction Contracts Act and how best to utilise it. So to begin with, our first question here is, what exactly is the Construction Contracts Act about? What is this legislation intended to achieve? Well, essentially, the Construction Contracts Act, it's about security of payment. So there's really two twin features here that apply under this general banner of security of payment. Firstly, the Construction Contracts Act sets up a regime whereby it implies terms into construction contracts and also prohibits certain terms that are considered generally to be unfair or unpalatable in commercial transactions. And secondly, and as indicated, the other key aspect of this security of payment theme to the Construction Contracts Act is the provision of rapid adjudication of payment disputes, and this is with a view to ensuring that money continues to flow in the contractual chain. So if, for example, you're working as a trade contractor for a builder, for instance, or you're a builder carrying out works for a homeowner, if the person who's meant to be paying you, say, a progress claim doesn't pay you, then the Construction Contracts Act will provide a very quick means to resolve that dispute through an adjudication process whereby an independent adjudicator will basically make a decision as to whether or not the outstanding money, whether or not that progress claim needs to be paid or not, and that's with the overarching excuse me, purpose of keeping money flowing in the contractual chain. Now, as I mentioned earlier, the Construction Contracts Act was recently amended, and there's quite a number of amendments that were made. This was back in November 2016, and the intention of the amendments was essentially to provide greater protections for subcontractors in pursuing claims for payment up the contractual chain. So the key theme of the amendments was about increasing the ability of some subcontractors to claim outstanding money, whether it's from a builder or another principal contractor, but basically going up the contractual chain to recover payment. Now, when do the various amendments actually apply? Well, there's two starting dates, and I'll cover off on these as we go through the presentation. The amendments in relation to implied terms that are implied into construction contracts, they commence on the 3rd of April this year, so there's additional time to allow industry participants to adjust to the various changes to the implied terms, which we'll deal with in this webinar. And then all other amendments, and these are amendments mainly in relation to the rapid adjudication process itself, these amendments commenced on the 15th of December last year, and I'll cover off on the key amendments as we progress through today's webinar. So, we've talked about what the purpose of the Construction Contracts Act is. It's essentially security of payment by implying certain terms into construction contracts, and also by providing for rapid adjudication of payment disputes arising under construction contracts. Well, first of all, there's a threshold question to be asked in terms of whether or not the Construction Contracts Act will actually apply to a contract that you're dealing with. The CCA applies to construction contracts, and this has a technical legal meaning under the legislation. Essentially, a construction contract includes most forms of building works, so this legislation is very relevant to participants in the residential and commercial building industry. Includes most building-related works, including but not limited to works in relation to civil engineering for a project, demolition works, electrical work, plumbing and gas work, maintenance works. So as you can see, these are all relating to the physical carrying out of works in relation to a building project. Also includes other examples such as painting and decorating work, the supply of building materials, the hire of plant or equipment for a construction job, earthworks and landscaping. And in addition, the definition of a construction contract also includes contracts for professional services in relation to a construction project. And this would include things like architectural drafting, design, surveying and engineering as well. So as you can see, the definition of construction contracts really does capture a whole raft of activities that occur in the context of a residential or commercial building process, which means that there's a lot of scope for HIA members, for instance, to utilise the Construction Contracts Act as a way of assisting to resolve payment disputes. Now, as I mentioned, one of the hallmarks of the Construction Contracts Act is that it implies certain terms into construction contracts, and it also bans certain terms in construction contracts to which the legislation applies. Firstly, and significantly, the legislation bans the inclusion in construction contracts of paid if paid clause. So here we're talking about cases where, for example, you have a contract between the principal contractor and a subbie underneath, and the subbie only gets paid if the principal contractor gets paid by the client. So there could obviously be considerable delays there, potentially, in the principal contractor getting paid, which then in turn means that the subcontractor down the chain is effectively waiting indefinitely for payment. And in a similar vein, the legislation bans the inclusion of paid when paid clauses into construction contracts. And of course, this is when, for example, the principal contractor has in that contract with a subbie a term that the principal contractor is only obliged to pay the subcontractor when the actual principal themselves is paid. So again, these types of terms can be quite adverse to the interests of subcontractors, and they're strictly prohibited under the construction contracts legislation. Now, in additionally and significantly, this is one of the amendments that was made very recently to the legislation. So from the 3rd of April this year, a contract term cannot require payment to be made under a construction contract more than 42 calendar days, previously 50 days, after payment is claimed after an invoice or progress claim. So in other words, the payment terms between, for instance, a principal contractor and a subcontractor cannot be in excess of 42 calendar days. Previously, under the legislation as it existed previously, the relevant time period was 50 days. So the reason why this change is taking effect on the 3rd of April this year is to provide industry an opportunity to adjust any practices or customs in relation to payment terms. So to reiterate, from the 3rd of April this year, the contractual time frame for payment of a contractor, for instance, it can't be in excess of 42 calendar days. Now, we've talked about terms that are prohibited in construction contracts by virtue of the Construction Contracts Act. What about the terms that are positively, proactively implied into construction contracts? Well, under the Construction Contracts Act, where there are no written contract terms in place, then the CCA basically fills the void. It fills the gaps by implying certain terms. And of course, this is going to be very relevant in the context of, for instance, an oral, a verbal agreement in relation to construction works. In these kinds of circumstances, the Construction Contracts Act will fill those gaps in and imply various terms into that agreement, even though, say, it was an oral verbal agreement. Now, the Act implies terms in relation to a contractor's right to be paid on time, how variations are to be paid and dealt with under the contract, as well as the contractor's entitlement to claim progress payments. Additionally, when and how progress payment claims can be made, and this is an important term which is implied because in the context of oral agreements, obviously there may not be a great deal of clarity or certainty around what exactly the payment terms are for the works that have been orally agreed upon. So the Act will be filling the void here and implying a methodology for how progress claims can be made and when they are to be made. Additionally, the Act will imply terms in relation to outstanding payments, so it will enable a contractor to claim interest on any outstanding amounts that are owed to them, say by a principal contractor. In addition, the Act will imply terms in relation to when the ownership of goods passes from a contractor to a client or principal contractor. Also, there are duties outlined as to unfixed goods on site in the event of insolvency of a principal. So this is to deal with situations where, for example, the principal contractor goes into insolvency, the subcontractor has delivered unfixed goods to the site. What are the rights then of that subcontractor to take back those unfixed goods to essentially try and compensate for their loss as a consequence of the principal contractor going into insolvency? And finally, the Act also implies duties relating to the holding of retention monies in trust as well, as members who carry out work in the commercial space would no doubt experience in the commercial arena. The holding of retention monies is much more common than in residential projects, and in the context of construction agreements where there aren't written contract terms, the Act will be implying certain duties on the parties in relation to the holding of retention monies. Now, I should also note that this slide basically provides a very high-level overview of the terms that are implied. At the end of this webinar, we'll be sending you all a detailed HIA information sheet outlining further details in respect of each of these implied terms and how they actually work in practice. So we've talked now about the intent of the Construction Contracts Act, and against that backdrop, what kind of terms does the Act prohibit from being included in construction contracts, as well as what terms does it proactively imply into construction contracts. Our next part of the webinar is now going to be covering off on the rapid adjudication process, which is allowed for under the Construction Contracts Act. So what is rapid adjudication? Well, there's a number of key features which define this rapid adjudication process. Firstly, it is an informal and fast process for the interim resolution of payment disputes. Now, what I mean here by interim resolution of payment disputes is that during the course of a construction project, if an application for rapid adjudication is made, the adjudicator will be determining there and then whether or not the money claimed is due and payable or not. If it is payable, then the adjudicator will make a decision that the money needs to be paid, for example, by the principal contractor to the actual contractor, and this is with a view to ensuring that money continues to flow in the contractual chain. But there is then still the ability of the principal later on, after the adjudicator's decision, or say after the construction project has moved towards the back end, towards completion, there's the ability then for the principal to contest the decision of the adjudicator and make an application, for example, to the courts on the basis that actually we weren't obliged to pay the contractor that money. So one of the features of the adjudication process, as it's a very fast process, the adjudicator is only going to be making a decision there and then as to whether or not money is payable, and simply based on the facts that are available at the time of the application for adjudication. Now, another key feature of the adjudication process is that the adjudicator makes that decision based on the written evidence of both parties. So the rapid adjudication process excuse me, is not like going to court, for example, where parties could be called upon to give evidence, where they could be cross-examined, and where evidence is tested. The adjudicator is making a decision based on written information that the parties provide. Now, we'll go into the process of adjudication a little bit later on, but just at a high level now, the process for initiating rapid adjudication under the legislation involves the applicant, so the person who's owed money, physically writing out their claim in an application form. The other party then has to submit a response in writing, and then the adjudicator makes a decision based upon the information contained in the application and the information contained in the response, so that the adjudicator isn't, for example, going to be arranging for the cross-examination of various parties or anything like that which occurs in a court setting. The assessment of whether or not money is payable or not at a particular point in time is going to be based simply on written evidence. Furthermore, the other key hallmark of the rapid adjudication process is that an amount that is determined by the adjudicator as being owed under the rapid adjudication process, it must be paid, but can later be reviewed by a court. So even though the adjudicator is making a decision at a particular point in time as to whether or not money needs to be paid, the other party is obliged to comply with that decision of the adjudicator. However, later on down the track, say when the project is closer to completion, the party who is owed to pay money can actually seek a review of the adjudicator's decision, such as by a court, for example, because there may well be additional facts that have come to light which show that perhaps the money that the adjudicator ordered needed to be paid is not in fact due and payable after all. Now, the question which firstly arises when we're talking about the rapid adjudication process is who can actually initiate an application for rapid adjudication? Who can apply under the Construction Contracts Act to have that payment dispute with somebody actually resolved through adjudication? Well, the application, the scope of persons who can apply is quite broad in relation to a construction contract. An owner, aka a homeowner, can make an application for rapid adjudication in relation to, for example, a payment dispute concerning a construction contract with a builder. A principal contractor, such as a builder, can utilise the legislation. Contractors and subcontractors, for instance, a subby of a builder or a principal contractor, can seek rapid adjudication in relation to non-payment of a progress claim by the builder or principal contractor. Suppliers to the site in connection with the construction works can also apply for rapid adjudication. And in addition, as we mentioned in one of the earlier slides, the definition of construction contract also includes contracts for the provision of professional services in connection with the construction work. So professionals such as architects, engineers, surveyors who've carried out services directly related to the actual construction, they can also utilise the rapid adjudication process in relation to recovering any outstanding amounts. Now, another point to mention here is on the topic of who can apply for rapid adjudication, is that an application for rapid adjudication can be brought both upstream and also downstream along the contractual chain. So what we mean here is that a subcontractor can claim upstream against the principal for unpaid progress claims if the subcontractor has carried out works for example, for a builder and the builder hasn't made payment within the required time frame, then the subcontractor can make an application for rapid adjudication of the payment dispute up the contractual chain against the builder. But also, a claim for rapid adjudication can be brought downstream along the contractual chain. By way of example, a principal might seek to utilise the rapid adjudication process in making a claim against a subcontractor or a contractor for liquidated damages under the construction contract in the event that, for example, the subcontractor didn't complete their scope of works within the contractual time period specified under their construction contract. So what we'll do now is just look at a high-level flowchart indicating how this works in process, how claims can be brought both upstream and downstream along the contractual chain. So in a typical situation in the residential building industry, you'll have your homeowner. Our homeowner here has a building contract with a builder to build their home, and as will often happen, a builder is going to be engaging a number of specialist subcontractors to carry out work, such as brickies and chippies, electrical workers. So the builder in turn has subcontracting agreements with various subcontractors. So at the end of the contractual chain, we have the subcontractors. Now, subcontractor under the Construction Contracts Act can seek to bring an application for rapid adjudication of a payment dispute with the builder as against the builder, so the subcontractor can claim upstream against the builder, and in the event that the homeowner is defaulting on making progress payments to the builder can also be making an application for rapid adjudication of that payment dispute upstream against the homeowner. And as I indicated before, the legislation can then also be utilised downstream along the contractual chain. For example, if the builder and the subcontractor have in place an arrangement whereby the subcontractor is to complete works by a certain date, or it's the case that the homeowner requires works by a certain date and there's a provision for liquidated damages under the contract, so the builder, for example, has to pay the client a sum of money per day for each day they go overtime, then the homeowner could seek to use the legislation, could seek to use the rapid adjudication process against the builder in relation to that dispute. Now, another question that arises, we've talked about who can utilise the rapid adjudication process, which parties in a construction context can use the legislation. Well, the next question is, when can rapid adjudication be sought? And of course, because the process is a rapid one, this means that there's some very strict timeframes in relation to bringing an application for adjudication, responding to an application, and also the timeframes for an adjudicator themselves to make a decision in relation to a payment dispute. Now, where a progress payment has not been paid, a written application will need to be served on the other party within 90 business days. Previously, it was 28 business days, but as we mentioned before, late last year, this was amended to 90 business days. So the written application for adjudication needs to be brought, for example, by the contractor against, for instance, a principal contractor within 90 days of that progress payment becoming due. So the legislation, as you can see, has been amended to provide some additional benefits for contractors in that it allows a subcontractor additional time within which to make an adjudication claim against a principal contractor. Now, because it's 90 business days, it's to be borne in mind that a business day excludes weekends, public holidays, and the industry shutdown period between the 25th of December and the 7th of January. Now, the relevance of the inclusion of this definition of business day here is that in times gone by, when the application for adjudication had to be made within 28 calendar days, it meant that you could have a situation whereby essentially as a bit of a Christmas gift, a subcontractor could bring an application for rapid adjudication against a principal contractor during the Christmas holidays, during the industry shutdown period, which would mean that the principal contractor would be in a somewhat stressful situation in having to respond to this application for rapid adjudication during the industry shutdown period, where they themselves may be on holiday and they may not have available, for example, their law firm or other legal advisors to have conduct of responding to the application for rapid adjudication. So now it's 90 business days within which to bring the application, and it's business days. It excludes the weekends, public holidays, and the industry shutdown period. Now, what exactly is the application process for rapid adjudication of a payment dispute under the Construction Contracts Act? Well, there's a process which is prescribed or mandated by the Construction Contracts Act itself, and this needs to be strictly followed if you're seeking to utilise legislation for the rapid resolution of a payment dispute. At a high level, and we will go into some further details, the first step is that the applicant for adjudication, so the person who's owed the money, must serve a written application on the other party to the construction contract who owes them money. So serve means you actually have to be providing a copy of your claim to the other party. They need to be aware of it. It has to be provided to them. And then once an application for rapid adjudication has been served on that other party, one or two things can happen. Either the parties themselves can then agree for the application to be provided to a suitable adjudicator, so the parties themselves agree upon who they want to adjudicate that dispute, or alternatively, and as often happens, agreement isn't able to be achieved. So then what will need to happen is that the applicant for adjudication will then serve that application on either an adjudicator themselves or what's known as a prescribed appointer, who will in turn appoint an adjudicator. So to build in some further details around these ideas of an adjudicator or a prescribed appointer, adjudicators are generally people who are construction contracts experts. They comprise usually of engineers, lawyers, former builders, people with a wealth of experience in the construction industry. Now, this is a private process, so the actual arrangement that would be entered into between the adjudicator and the parties would be one where usually the parties both agree to pay the adjudicator's professional fees for having conduct of the adjudication, and details of adjudicators who can carry out adjudications under the Construction Contracts Act. Information on all the persons is available on the Building Commission website, so you can literally go there, click on the section titled Rapid Adjudication under the Construction Contracts Act, and you will be presented with a list of adjudicators and their professional biography, so you can decide who you want to basically have the application dealt with by. The alternative situation is, rather than providing the application for adjudication directly to one of these adjudicators on the Building Commission website, there's also the ability for the applicant to serve a copy of the adjudication application on a prescribed appointer. So this is an independent third-party body that is authorised under the Construction Contracts Act to appoint adjudicators in relation to applications for adjudication under the legislation. And as many of you may have found, there's a number of industry associations, for instance, who are registered as prescribed appointers. So in terms of kicking off an application for rapid adjudication process, what generally happens is that the applicants, the person who's owed money, they serve their application for adjudication on the other party. The other party obviously is not going to be keen to go ahead with adjudication, so the applicant will then simply serve a copy of their application for rapid adjudication on, say, a particular industry association like the Electricity Contractors Association, who can then in turn appoint an adjudicator to deal with the dispute. Now, when commencing an application for rapid adjudication under legislation, it's important to use the actual form which the Building Commission has developed and which is basically the form that's required to be used for commencing an application for rapid adjudication, and it's the Form 2 application for adjudication Building Commission form, and this is available on the Building Commission website. It can be downloaded in Word format, so you can type out the actual claim, and you have to basically provide details around the construction contract in question that you believe you're owed money under, and also set out the various payment terms under that contract, what you've done to request payment, when the payment was, when it became overdue, and provide particulars in respect of how much money you are owed. So we've just talked about what the actual technical process is for commencing an application for rapid adjudication under the Construction Contracts Act. The second thing we need to cover here is then what's the process for responding to an application for adjudication. So for example, what if you are a principal contractor and your subcontractor has just served you with an application for adjudication of a payment dispute? Well, there's also a prescribed mandatory process under the legislation for how a response is to be dealt with. Basically, a party who is served with an application for rapid adjudication must then in turn serve on the other party and the adjudicator a written response within 10 business days, previously 14 calendar days, of receiving the application for adjudication. So as we mentioned before, an adjudicator will make a decision as to whether or not money is payable or not based upon the written evidence of the party. So they'll be looking at the details set out in the applicant's application, and they'll be looking at the response in the actual respondent's response document, which is why it's very important that if you are ever served with an application for rapid adjudication, you do actually provide a response within 10 business days. Otherwise, you do run the risk of a decision being made by an adjudicator without you having participated in that decision by providing your response. Now, it's important again that these timeframes are strictly complied with. If you do receive an application for rapid adjudication, your response is due within 10 business days. So it's very important that that timeframe is complied with, because otherwise the adjudicator can make a decision not to accept the response. And also, in a similar vein to the application form, the response form is something that has been developed by the Building Commission, and you'll need to use their template response to application for adjudication form. In a similar vein, again, to the actual application form, you need to be providing details in the response as to why it's your contention that money owing, or should I say money under a construction contract is not actually owing at that particular point in time. Now, we've talked about the application process. How do you respond to an application? Our third point here we're going to cover off on in relation to the overarching process for rapid adjudication under the Act is then the timeframes in relation to a decision being made by the adjudicator. Now, after the adjudicator has received the application, they've received the response. From receipt of the response, they've now got 10 business days, which was previously 14 calendar days prior to the amendments, of receiving the response to make their decision, or alternatively 10 business days of the last day for service of the response. Now, this is very relevant if we go back to our previous slide in terms of the actual time frame for submitting a response. If you receive an application for adjudication, you must respond within 10 business days, because the adjudicator can still move ahead and give a decision even if you did not actually provide your response within that 10 business day period. So if you don't comply with the 10 business day rule, you run the serious risk of a decision being made simply based on the applicant's application for adjudication without any input from you. And in terms of the outcome of the adjudication process and the various powers of an adjudicator may make a decision to order that an amount be paid by a specified date by the other party. So the adjudicator may order, for example, that a builder pay a subcontractor a particular progress claim stage that the subcontractor has claimed for, and this must be paid by a specified date. The adjudicator also has the power to dismiss an application if it has no basis, and the applicant for adjudication may also, during the adjudication process, withdraw their application, in which case the adjudicator may then in turn dismiss the application based on the applicant's withdrawal. And finally, and this is very relevant in relation to amendments that were made to the Construction Contracts Act recently, the adjudicator also may make a decision which gives effect to any settlement of the dispute reached between the parties during the adjudication. So what this means is that you could have a situation where the subcontractor makes an application for adjudication against a builder. The builder submits a response, but during that time the parties are in negotiation and they end up reaching a commercial settlement prior to the adjudicator making that decision. Now in these circumstances, the adjudicator may make a decision which gives effect to that actual settlement agreement, so you don't have a situation where, for example, the parties have agreed on one outcome, but now the adjudicator is moving ahead with the adjudication process and makes orders which are different to that settlement agreement between the parties. Additionally, in terms of compliance with the decision of the adjudicator, it's relevant for me to note here that the decisions of the adjudicator are legally enforceable. If another party fails to comply with the adjudicator's decision, then a number of things can happen. Firstly, the party who's affected may exercise a right under the construction contracts legislation to suspend the performance of further works without risk of liability. And in addition, should I say, the person who is essentially affected may make an application to the court to have the adjudicator's decision enforced against the other party. Now really just to finish off today's webinar, just with a couple of points to note in relation to tips and traps with using this legislation or responding, say, to an adjudication application under the legislation. The first thing that I would emphasise to you all is the importance of ensuring that your construction contract is very clear in relation to progress claim stages. So when exactly will a progress claim stage become payable? When, for example, if you're contracting with a contractor, at what stage can they actually legitimately make a claim on you as a principal contractor for payment? And furthermore, making sure that in your contract, in your construction contract, you don't have payment terms that go beyond 42 working days. In addition, that if you are going to be utilising the rapid adjudication process, that you do act strictly within the various timeframes for bringing and responding to an adjudication claim. Otherwise, if you're outside the timeframe for bringing the claim, then you'll be time barred from bringing it. And if you're outside that 10 business day time frame for responding to an adjudication claim, then you run the serious risk of the adjudicator proceeding to make a decision simply based on the applicant's application for adjudication. And finally, the final thing we would advise is that even if you're a party to an adjudication under the legislation, still do engage in attempts where possible to negotiate a resolution with the other party, because there is now, of course, as indicated earlier, the ability for the adjudicator to make a decision which reflects a commercial settlement of the payment dispute which is reached by the parties during that adjudication process. And of course that's going to be desirable with a view to preserving a business relationship, for example, and ensuring that, for example, that if an amount is owed to you, that it can be resolved amicably on commercial terms, rather than having to go through the full process of waiting for a decision to be made by the adjudicator, and then if the other party doesn't comply with it, then having to go through the court process to then enforce it. So if you can negotiate out a resolution where possible, then that's generally going to be the most ideal outcome. And look, just finally, I should note that here at HIA we're here to help you and provide as much information as advice as we can, including in relation to the Construction Contracts Act. We always do advise that you should seek some specific advice from us with respect to your particular circumstances, so that our information, advice and services can be tailored to you accordingly. And to this end, you can contact your local workplace advisor, such as myself, by contacting our member line on 1300 650 620. All right, well, thank you everybody for today. I think we'll now, Kerry, move into having any questions if there are any. And of course, if you're not in a position to ask any questions right now, you can always email me on this email address here, the WA_ all in capital letters, IR and legal at hia.com.au, and I'll endeavour to contact you to discuss your query further.
Thank you, Michael. Just in regards to the adjudication, is there a set cost involved?
The costs of an adjudication, because it's a private process, the costs are ultimately going to depend upon the actual adjudicator in question who is appointed to deal with the matter. So each adjudicator's fees can be unique, and also the fees will depend upon the complexity of the matter. By way of example, an adjudication in relation to, say, a residential building contract where, for example, a subcontractor is trying to claim, say, $5,000 from a builder, the fees involved are going to be much less than, say, for example, if you're dealing with circumstances where, say, the builder themselves is owed a $60,000 progress claim stage by the owner, and consideration in devising the fees will also be had to the complexity of the construction contract in question. So, for example, disputes in relation to commercial construction contracts, such as for a high-rise development, will generally attract a higher level of professional fees due to the greater level of complexity of issues and the time that's going to be spent by the adjudicator in considering the application.
Okay, great. So we have a question, and I guess this one's going downstream. What will the adjudicator want to see? Example, photos for proof of works not done or faulty works completed, and invoices from other subcontractors that have had to be used to fix the complete works.
So in the context of downstream claims, for example, builders seeking to claim costs against a subcontractor, this is really only going to be relevant in the context of, say, where there's a liquidated damages clause in the agreement between the builder and the subcontractor, whereby, for instance, the subcontractor has not completed the works on time for whatever reason, and as such there's a time overrun. If there's a provision under the construction contract between the subby and the builder for the builder to be entitled to claim liquidated damages, say $100 a day, then the builder can use the rapid adjudication process in relation to that claim. However, if the nature of the builder's claim is one purely for defective or faulty workmanship, then that's something that wouldn't be dealt with in the context of the Construction Contracts Act, because the Act is purely for the resolution of payment disputes, whereas a matter which involves claims of defective or unsatisfactory workmanship is something which is different and would normally be agitated, for example, through the courts.
Oh, okay. So I understand. So in this case, you wouldn't be able to use this process. You would use a different process, yeah.
Yes, that's right, because the Construction Contracts Act is about keeping money flowing in the contract chain, so it's about being able to point to an ascertainable sum of money that's owing and then submitting that for rapid adjudication, and the adjudicator will make a decision as whether at that point in time that money needs to be paid or not.
Okay, great. Well, that was the only question I had to read out, so unless somebody has another. Oh, yep, sorry, one's just come in. Can this adjudication process be used at any stage of the contract life? For example, if there is a dispute on the final payment amount?
Yes, it can be used at any stage during the actual construction process. So, for example, if early on in the job, if say there's 6 progress claim stages, and there's a default by the other party on the second stage, then a claim can be made. If the default happens to be in relation to the last payment, then as long as there's a construction contract under which the money is owed, then the rapid adjudication process can be used in relation to that.
Okay, great. I think that was the last question I had, but as Michael said, if you think of any other questions afterwards, or if you listen to the webinar again and some more questions pop into your head, you have Michael's email address or my email address, so always feel free to send them through to us. I just want to thank you for joining us today, and thank you, Michael, once again for running a webinar for the WA members. I will have this up on our website shortly, and as Michael mentioned, I think we have some information sheets which will be sent out with the email, which will let you know when the recording is available. So thank you, everybody.
Excellent.
Thank you, Michael. Have a good rest of the day.
Thank you. Thanks, Kerry, and thanks to everybody for participating today. Have a lovely day.
Thank you. Bye.
Bye.